Hello, everyone. This is Briar and Steve, and I am here with my colleague, Steve Helland.
Hi there.
And we are here to talk today about EHR contracting and data security. And just some housekeeping notes before we start. If you have any questions during the presentation, and we hope that you do, you can hover over the bottom of the screen to see the chat feature, and that is definitely the easiest way for us to get questions. If the audio cuts out during the presentation, please use the dial-in number that is provided for you. Hopefully that will not be the case. Next month, our webinar is going to be a very special Valentine's Day edition. Katie Ilton and David Glazer will be talking about audits and overpayment allegations and streamlining your appeals process. And based on past presentations by those two, it should be an excellent presentation. And then in March, we'll have one of our great employment lawyers to talk about harassment in the workplace. And that could be used actually as a good training session for all employees, including physicians. Steve and I just recently participated in that presentation ourselves, and I think we could probably agree it was almost completely painless.
Agreed.
So I encourage you to sign up for that. And then finally, at the end, we would love for you to fill out the survey after the webinar. We do read them, and we really appreciate all your feedback. So with that, we will go ahead on the EHR contracting presentation. A brief overview of what we're talking about today. We'll talk a little bit about what is actually required to be in an EHR that you own and operate. We'll talk some about HIPAA-related issues, selecting a vendor, and then those key provisions that you should have in every EHR agreement. At the end, we'll cover a little bit about data security risks, although I think probably most people are unfortunately very well aware of most of those. So what is actually required? What are the must-haves for electronic health records? The simplest way to get everything that you need to have is to use certified EHR technology. That means that it's been certified by the Office of the National Coordinator for Health Information Technology. ONC used to be ONCHIT, but they have made that a much more palatable acronym. So certified by the ONC. That is the case whether you're using a full electronic health record or a module. You should be using a system that is deemed certified EHR technology. If it's certified, you know that it's got all of the necessary technological capability and functionality and security that you need to meet the meaningful use criteria. And then the certification also helps you know that the products and systems that you're using are secure, can maintain that data confidentially, and can work with other systems to share the information. And that is really what you're looking for in your EHR. Just a bit about EHR incentive programs. I'm not going to get into details of these because there are a lot of details, and we want to keep this focused on the contracting process. But keep in mind that eligible professionals and eligible hospitals and critical access hospitals that are participating in the incentive programs do have to show that you haven't restricted compatibility or interoperability of your certified EHR. There is now a requirement that you attest to 3 specific statements about how you implement and use your certified EHR technology. Those are together referred to as the Prevention of Information Blocking Attestations. That attestation has to be submitted. You don't have to actually show any documentation in order to attest to that, but obviously, as in the case, anytime you're attesting to something to the government, keep in mind that if the attestation is false or becomes false, that can create some major problems for you. So make sure that you can truthfully attest to what you are signing there about information blocking. And then continue to submit evidence of meaningful use to avoid that payment reduction from Medicare or get the incentive for Medicaid. To do that, you do need to be meaningfully using a certified EHR.
Hey, Brian, I'm going to just jump in if I can ask you a question. So you just a moment ago talked about the certified EHR, and one of the topics we're going to talk about later are your suggested terms. And so I'm going to talk there about warranties. One thing I didn't have that maybe I should be adding, and here I'll look to you, is should there be a warranty that the vendor is going to give you a certified EHR and that it will remain certified, or what comment might you have about that?
Yeah, I think that is a really good idea. I think it makes sense to have a warranty that says that the vendor is warranting that this is certified EHR technology. And if they object to that, then it's worth finding out more about why they are objecting. Is it not certified? Is it something that doesn't need to be certified? But at least put it in there and have them react to that.
Great, thank you.
Just a bit about donations of EHR technology. This is still okay. It allows for the donation of up to 85% of the cost of an EHR from a hospital to, for example, a physician group or physician. It's an anti-kickback safe harbor and a stark exception. They were supposed to have expired quite some time ago, but they've been extended now until December 31st of 2021. It's unclear what will happen after that, but if you're getting subsidized right now, or if you're doing subsidization, that is still okay. They're complex regulations, so if you're going to be providing or receiving an EHR function at less than fair market value, review those requirements carefully and make sure that you're complying with all of those obligations. A bit about HIPAA and EHR contracting. As you work with your vendor, you should be considering HIPAA's requirements on things like the patient's rights obligations under HIPAA. Patients have a right to amend and access and request restrictions of their information, including, of course, not sharing specific information with a health plan if the patient has already paid for or plans to pay in full for that out of pocket. If a person is requesting an electronic copy of their PHI, you're going to have to provide that in the access, provide the access in the form and format they request if it's readily producible. And so you want to make sure that you can do that. That includes images and other data that's supposed to be included in electronic copies. You want to make sure that you can capture everything and that your EHR has the capability to do that. So when somebody requests information, you're able to accurately gather things. So that includes phone notes, provider notes, anything else that you would expect to see, that you would base treatment decisions on, should be able to be provided to the patient. Transition of records to a new vendor can also be a HIPAA issue. You do have to be able to provide the information, and we'll talk about that a little bit more on the next slide. But be aware that that transition can be a problem. You should execute a business associate agreement with your vendor if any of these bullet points are true. If they're creating, maintaining, receiving, or transmitting PHI, including maintenance in the cloud. If they're going to have access to PHI, including for any troubleshooting of the functionality that they're providing. And also, you should have indemnification in your business associate agreement for breaches. That is recommended not just where the vendor agrees to pay notification costs, which are generally pretty minimal, but where they're agreeing to reimburse for all the problems that they would create if they caused a breach of PHI, including things like forensic investigation, recreation of information that was on a lost laptop, for example. There can be a lot of costs, and notification is just the teeny tip of the iceberg.
I'll just actually piggyback on that if I can for a second. I can just look at I'll not cover this point later on. So, so Briar comes at this mainly from, I think, the point of view of a health lawyer, whereas I come at this from the view of a tech lawyer. And in the world of security breaches, I'll totally agree with what Briar just said. But then I'll also tack on a thing that I'm seeing more and more in my agreements, where not just PHI, but any kind of personal information is held about individuals, is that if there's a breach, there's also a stipulation that the vendor, in addition to all the other costs that Briar just referenced, the vendor will pay for 12 months to 24 months of credit monitoring or security credit monitoring for impacted individuals. And in some of the breaches I've worked on recently, that's actually been the biggest cost. That can be, I think it's the current kind of market rule of thumb is about $100 per person per year. So you can see how when you do that math out, right, that can add up pretty quickly. And if you can get that protection in a contract, I think that can be really valuable.
Definitely agree with that. Transition issues, we can talk a bit more about this and some of the more egregious problems with transitions where there is actual purposeful information blocking. But even when both parties are trying their best on this, the transition of records and information can be a problem. And I know Steve will be talking about this. But again, keep in mind that each entity has an obligation to make sure that access to PHI is available for individuals. You have to ensure availability of your health information in general. So if you're not able to get the information and it is out of your control, that can be a major HIPAA issue. So to the extent you can, make sure those transition issues are addressed in the contract language. How much time is there going to be after termination for transition or prior to actual termination? What tools are going to be available during and after the termination process to assist? For example, will they let you continue to use the software solely for transition purposes? Will they have personnel that will assist you? Are they guaranteeing that someone will help you with those issues? And also, is there going to be a separate payment required for that? I would generally advise no, there shouldn't be a separate payment, but some vendors do insist that if they're going to be helping with that, they require some form of payment, and I would say keep that as low as possible.
And let me just follow up on that because we can cover it here and maybe then not cover it later on. So, Briar, I agree with everything that you said. Folks who are listening will probably think like Briar and I have some like prior agreement that will agree with everything each other says.
I do. I have a little note card that says agree with this.
So the only question I have actually, Briar, for you related to transition issues was that's in my non-HIPAA covered agreements, I will kind of have a paragraph or two describing all the different things I expect the outgoing vendor to do to help the incoming vendor along the lines that you just described. Even though we're under a HIPAA context, could I just make a reference to HIPAA to say, a vendor will comply with HIPAA, including transition issues, or do you recommend actually spelling out the particular things that they do, like you just said?
I would recommend spelling it out. The HIPAA obligations here are sort of a backup approach because I think many vendors interpret their HIPAA obligations differently. Even when OCR has provided some guidance on what they are expecting, a vendor might say, I'm protecting the information and that's what I need to do and you're on your own for transition. And it's much, much easier if you have that language there ahead of time so that you can say, you've already agreed to this. We need to do this rather than trying to fight it out while they are keeping your information away from you.
Okay.
Make sure that regardless of the business associate status of a vendor, so even if the vendor is not going to be a business associate because they don't have access to PHI, make sure that whatever new technology you're implementing that's part of your EHR is part of your updated risk assessment. And as most of you know, that risk assessment is a HIPAA obligation under the security rule. It is an ongoing obligation. It's not just a once a year thing. If your technology changes your EHR environment, it should affect your risk assessment and you should be updating that. That's true for any updates or upgrades too. You should be assessing how does this affect the security of the information that we have. Also consider how are you going to be transferring information to the vendor. If you're going to be transferring information to the vendor, is it going through a VPN? Is it going via email, emailed stacks of documents? Will there be direct access to your EHR? If so, what kind of access is permitted? And are they going to sign user agreements? Will they have their own passwords? How can you track their access? So really consider how are they getting your information and how are you able to protect the information that they get.
I'll just chime in here with like a horror story from the risk assessment point of view. So one of my clients last year was using a third-party hosting service to host their system. And they also engaged a different third-party consultant to help do some risk assessment. And that included penetration testing, which is the IT word for they try to hack in. Well, nobody cleared that with the third-party hosting service. And so they ended up crashing part of the third-party hosting service, not just for my client, but for some others. And I'll say the hosting service was extraordinarily unhappy as that breached the terms and it ruffled others elsewhere. So depending on how robust your risk assessment is, if anybody talks about penetration testing, that should be the subject of a more detailed conversation and making sure that all parties involved are on board. And I've got to say, I'm not a fan of that under most circumstances. All
righty, good to know. We did have a question come in about how often we see vendors requesting caps on liability in business associate agreements, especially if they have limited amounts of PHI access or they're not getting paid very much by the covered entity for the product or service. I see that all the time where there's a requested cap on liability, and I generally am okay with a cap if it is really limited PHI when the risk is really low. I care a little bit less about it. But if the vendor is going to have access to either a lot of information or highly sensitive information, I would say you want that cap to be pretty high. My argument back to the vendor is often, well, if you guys are really not accessing very much PHI, you have very limited opportunity to screw it up, and so you shouldn't care all that much about what the limit is because you're saying we're not going to cause any problems. On the risk assessment side, again, you should do a risk assessment of your vendor before contracting, and Steve is going to talk obviously about the vendor selection process. But again, take a look at what kind of access they're asking for. What do they really need access for to do their job for you? How are they going to use the information? Are they going to be doing data aggregation? Are they going to be de-identifying information? Take a look at their policies and procedures on security and HIPAA. Take a look so that you can try and figure out what kind of security are you getting with them. Also ask if they're going to be using the information outside of the U.S. It's not an absolute no if they're planning to store information offshore, but you do want to be aware of that and maybe ask some additional questions about that. And then, is the vendor willing to provide you with information about their security processes, and does it make sense? If they're not willing, or it doesn't make sense, or it doesn't seem at all related to the service that you're getting from them, then that maybe is a red flag. And again, Stephen's going to talk about that.
Actually, I'll take care of it right now, actually, if you don't mind. So, or at least one part of that, which is sometimes during the contracting process, as Briar is just describing, there'll be this conversation with the vendor, and they'll tell you how great their security processes are, and maybe they'll even show you some policies or procedures. One of the things that I will try to do when I contract is I'll have a clause, whatever the clause will be on security, and it'll say, and by the way, attached as Exhibit A or X or whatever exhibit number it is a copy of the vendor's security policy, and the vendor agrees that they'll comply with their own policy. I think it's pretty hard for a vendor to say, no, I'm not going to comply with my own policy. And also that gives some real specifics. Whereas if you don't have it actually sort of formally incorporated into the contract, it's not worth so much. I mean, it's worth something in terms of having a sense of risk, but in terms of giving you legal remedies if things go wrong, you're not in nearly as good a place as if it's been formally brought into the contract.
So I definitely agree with that, and Steve has written that for me on a card too. But sometimes I will see in these agreements, they will agree to add their security policies, or I know you're going to talk about documentation, and sometimes they'll add language that says, as may be revised by vendor from time to time at its sole discretion. Right. Any thoughts on that and how that affects your analysis?
So I'm glad you asked that question, Briar. Thank you for reading the card. No, so here's my thought on that, because Briar's right, of course, that's very common language, and it's not crazy, right? And I respect that there can be some changes. Sometimes I'll try to get in a clause that will say, but any change will be favorable to customer, or it will be at least as stringent as the current policies, so they're not loosening their policies. So I guess my comment would be, number one, I'd let the vendor bring up that argument, although it is a respectable argument, and then I'd try to limit it if you can, but I also wouldn't make that the absolute deal point, right? If they'll give me a policy, I'm probably gonna, as long as it meets sort of industry standard, then I'm gonna be okay with it. The thing, though, that again I'll kind of preview, and I'm gonna have to try to figure out which points I've already covered from my own slides later on, and which I haven't. But I think that Briar brings up the concept of things that can change that the vendor does, and vendors will sometimes too try to point at hyperlinked terms. Like in their contract itself, they'll say, see our security policy at epic.security.policies.whatever, and I really dislike those hyperlinked terms, because then you don't even have a clue if they're changing. And vendors will try to, it's quite common to see a couple of different hyperlinks for sometimes travel policies, security policies, permitted use policies, a bunch of stuff. And I would really quite strongly encourage you as customers to say, you have an absolute right to know what is the contract that we're signing up for, and that shouldn't be a moving target that you don't have an effective way to find out about. So what I do then is I say, let's delete the hyperlink. Let's print out a copy of the current version as it is today when we sign the contract and attach it as an exhibit. And that way everybody's clear. So that's my little editorial comment there.
Definitely agree with that. And I should have said before, as we transfer over to Steve's slides, Steve is at Fredrikson as an internet software and technology transactions lawyer. He's a shareholder here, and he also does a bunch of work on website accessibility. So he is quite expert in these matters, and he is going to get right into the selection of vendors.
All right, thanks, Briar. And Briar and I will collaborate actually on these things from time to time when they come up. So we like working together on these kinds of agreements. Selecting your EHR vendor. So let me go up to kind of 40,000 feet and talk about what I see as the market in this space. And certainly, right, Epic, McKesson, and Cerner are the big three. And I think last I saw, they control about like 50% of the marketplace in electronic health records. But I was surprised by the second number. The total number of EHR vendors is somewhere between 600 and 1,000. And so there really are lots of different choices out there. I think that even among the larger players, I expect to see continuing evolution of who's dominant. Just as, right, for those of us who, like me, who had an early MySpace account and thought that this Facebook was just like an upstart. And now I see from your people that, right, Facebook is out and Snapchat and other things are in.
Your MySpace page, though, is still great.
Yeah, thank you. I keep updating it from time to time. I'm wondering why it doesn't get more traffic. So in any case, I was going to say, Briar earlier mentioned the comment about transition, and I think that transition will continue to be substantial as we see both individual customers like yourselves switching potentially to new vendors because they're dissatisfied or there are other changes. I'm seeing a lot of changes in the marketplace where one company is acquired by another company. That's certainly going to happen a whole bunch. And then there are other developments that we have yet to see how they play out, with artificial intelligence being just one. And I don't know that anybody really owns that space in electronic medical records. So I'll just say, be prepared for a shifting landscape in vendors. And just because, your a clinic similar to yours chose somebody, a vendor A, last year, 2 years ago, vendor A might not be the right choice in 2018 or 2019. So selecting the EHR vendor. Risk assessment, Briar's already talked about that. Selection committee, I think that these things always go better if you've got buy-in by kind of all your major groups, right? You'd want providers and users, IT, administration, and then some folks will hire an IT consultant to help them with their electronic medical records selection. That's a cost. I'll just say I think that there have been some, I've worked with some really reputable consultants in the space. I think that they've done a nice job of helping compare apples and oranges and whatever else there might be, because it can be tricky. All right, I'm not going to read all my bullet points to you. Pricing, it can be, I'll just say this, please remember to think about total cost of ownership over the duration, because just like your, maybe like your $1 shave club, the upfront cost can look very different than your overtime cost. There is, so cloud or software as a service, or some people call it ASP, versus installed, or other people call it on-premise software. I realize there's a strong shift towards the cloud or the ASP version. I see that trend continuing, but there are still vendors out there who offer the on-premise. Those contracts will look a fair, somewhat different in some critical ways. I'm not going to try to go into all of those, but I'll say that's a pretty fundamental choice. RFPs and proposals. So I'm a big fan of a formal RFP or proposal process where you get something back from the vendor that says, yes, all those meetings that we had together where you asked different questions, can you do this, can you do that? Will it interface with my lab software? What about my billing software? And you get a written answer to those questions, the things that are important to you. And those written answers tend to be, I'll say more often, in what we'll call human or regular English. Whereas what's in the vendor's kind of formal documentation is not always so clear. And what I really like to do when I can, and I'll say, and I ask for this every time I negotiate these contracts, is I tell the vendor up front, we plan to incorporate your written answers into the contract as part of our reps and warranties, so that we're really clear that we're getting what we think we're paying for. There's one other item here, and not to be overly legal, but this is a legal webinar. So there's a thing called the parole evidence rule. That's P-A-R-O-L, not parole, like getting out of prison. And what the parole evidence rule means is that when you're looking at a contract, or when a court looks at a contract, they really just look at what is in that contract. And that's why I say you should formally incorporate the proposal responses or the answers to your written questions, as well as these exhibits, as part of the contract. Because if you don't, all those sales materials and demos and contracts are a legal zero when it comes time to have the dispute. This is one of the things that comes up with, for me, it's one of the most often things. Clients call and they're unhappy and they say, in the demo, it worked really smoothly to show me this or that functionality, and now there's a dispute.
Steve, are you saying that sometimes they promise things that they are not actually delivering?
Briar, that is correct.
Oh
that there's a reason a successful sales team is compensated for being a successful sales team. And sometimes, right, what the sales team promises and what is actually provided for in the contract are different things. And that's not to disparage sales teams. I don't think it's not meant as a disparagement. It's just sometimes there's the nature of sales, and if you want to capture things that are important, you got to do it formally in the contract. Otherwise, when there is the dispute or the concern, like I say, all those other conversations, demos, and pieces of paper help you almost not at all. Closing out this slide, I select at least 2 finalists, and here, just my experience in negotiating quite a few of these are vendors. Most vendors behave quite differently if they know they're the only game in town for you versus if there's somebody waiting in the wings as a runner-up if the contract negotiation goes poorly. Some of my really savvy clients will occasionally, even in the negotiations, remind the, I'll say, primary vendor or first vendor that, I was just talking, staying in touch with vendor number 2 the other day, and they were saying that they could say yes to that clause or they could say yes to that request. So I think that you get different behavior when folks know that. And then last, I'll say a short window generally hurts you, the customer. Sometimes clients will call and say, okay, we've got the contract now. We've been talking to these guys for a couple months, but we want to sign in 2 weeks or 1 week. And you can do that, but your ability to get some, I think, important edits, sometimes to business terms, but especially on legal terms, really is reduced. An EHR contract is going to have a bunch of different pieces of paper or documents, a quote, proposal, a licensing, and I'm not going to read all of these. Other things that you might see besides the list here may be a separate hosting agreement, sometimes a separate installation or professional services agreement. And I'll use this as the occasion to talk about one of my important contract terms, which is particularly if your installer or installation vendor is different than your software as a service or your software licensor vendor, and that happens a decent amount of the time. What you really want to avoid is a finger pointing problem where the software vendor or the EMR vendor or EHR vendor says, yeah, our system works great. You have a problem with your installer, and the installer says, no, we've installed this perfectly. That's a glitch in the EHR system. So my comment here is, especially if number one is you can reduce this problem or actually almost make it zero if you decide you want to use the same installer vendor as the EHR or license vendor. So that's one thought. Another thought is if you're using an entity, a vendor that's different, but is maybe recommended by or is some kind of a gold partner or a platinum partner or whatever kind of made up term they have for those kind of alliances, then say that in the contracts, right? Say that in both the vendor contract and in the EHR contract that, installer is a gold partner of the recommended of vendor, and in the event of any trouble, they will work collaboratively to resolve the issue and not put you in the middle. All right, so I, as a lawyer, of course, love all the contract terms that I can dream up, and I think some of them are really great to protect you. But as, or perhaps more important than the contract terms that I come up with, is the power of money. And one of the things I'll see quite commonly with, again, the out-of-the-gate or initial contract that the vendors are proposing, will be that you pay a sizable chunk of money up front or on contract signing or within 30 days of contract signing. And sometimes that's like 100% of installation because they'll say, hey, I'm incurring labor costs up front. My comment to you, and I'll say this in negotiations, is that an 80% finished IT project is worth probably $0. And even a 90% complete project is worth probably about $0. And so what I recommend, I think it's reasonable to say, yes, the vendor will have some immediate labor costs. And so maybe you pay some amount, maybe half, maybe a third up front or pretty shortly after contract signing. But I really want you to save other payments if you can for measurable milestones, and particularly saving a decent amount until go live, successful go live, because your ability to say have the vendor move quickly to solve certain problems or issues, if they know they get a big paycheck or payday when that issue is solved, that's going to motivate them. Whereas if they've already been paid in full, you know what? Some of that punch list, they'll get around to it when they get around to it, and that might not be so fast. And
Steve, I think you made a good point when you said after successful go live. I have seen in some agreements where go live will just be a specific date, and you don't want a specific date. You want something where you have actually gone live and you're able to use the software as it's supposed to be used. So be careful and pay attention around that defined go live date.
I think that's a great comment. Let me also mention here, and this isn't on the slide, but I'll mention, and hopefully because folks are on this webinar that you have some faith that this is true, I'll say you can negotiate both not just pricing or financial terms, but also legal terms. And this is true with, I'll say, essentially all EHR vendors, from the biggest ones to small ones. Certainly, right, if you're negotiating with one of the big three and you're a small organization, you'll have less negotiating power, but not zero. Not zero at all. And so I would say feel empowered by that. Also, please remember that your negotiation power on a lot of these items is better now before you sign the initial contract, because once you sign the initial contract, maybe you'll add a module, or again, like I'll say, you'll add lab or billing or some of the functionality later. To the extent you can lock in pricing now, do, because your negotiation power, once you've sort of bought into the system, is much less later on. All right, moving forward. Pricing. Here's what I'll just say here is, well, a couple of highlights. One is read the definitions. I know that when people read contracts, that the definitions section is one of those that's super boring, but that's sometimes where vendors hide sneaky stuff. And make sure that you understand what counts as one user or one transaction. I sometimes joke that you could spend a whole semester of law school on counting, and that's really true, because you know what? When it comes time to pay fees or you've got a new user or a head count, this is one part of the contract that people will actually look back at. And so you want to make sure that you feel pretty clear, like what is a transaction, what is a procedure, or whatever the metric is that's driving your fees. That's something that people will look back on, and you want to make sure that if you think that Steve Helland, well, that counts as one user, but maybe I log in from work, but I also log in from a home or a remote account, and the vendor thinks that counts as two, you want to get aligned on those sorts of things. So price lock-ins, again, I won't spend time on that because that's relatively straightforward, but I will mention two thoughts that you can potentially negotiate up front. One is credit for acquisition. So if you might merge or have another relationship with another entity in the future, and they have a similar, maybe you're an ASP or a cloud-based system, and the entity you acquire, especially if it's one of the big three, maybe they have an installed version. I try to negotiate a clause that says if you acquire somebody else or merge it, you'll get some credit for the software licenses they've already paid for. The other, and nobody likes to think about this possibility, is right, what happens if your head count decreases or there are divestitures? Particularly if you're paying by user, you want the ability to pay for a smaller number going forward if perhaps one of your clinics would break off or move away. Implementation and acceptance testing. Again, I'm going to try not to read all of the bullet points here. Other than particularly in an installed software, that's where it's on premises at your facility. A lot of times you'll see like a 90-day or a 180-day warranty. Usually 90 is kind of the default. And there, number one, going back to counting, right? Those 90 days shouldn't start at the date you sign the contract because you're nowhere near in a position to start testing at that point in time. So it should be from what Briar said, right, which is sort of a successful go live in a live production mode. That's when your warranty starts, particularly for these really time-limited warranties. Failure to launch, this is kind of, I'll call it a Steve Helen original. I admittedly don't get this. I fail to get this more often than I do get it. And that's where if during the installation it is so bungled or so problematic or there's such a disconnect with what you were promised and what's showing up that you have the ability to terminate and say, you know what, take it away and give us all of our money back. I maybe get this 20 to 25% of the time. But for those really bungled implementations, that can be a nice term to have. We've talked about interoperability. Briar mentioned that earlier. Required operating environment. So this is something that the vendor should be able to give you a piece of paper saying, this is what we expect you, customer, will provide. You know, a internet connection with a certain size pipeline. Do you need to have a server? And the reason why I say it's nice to get this up front is I've had some cases where the vendor comes in and says, oh, this is great. We're happy to install your system, but please go out and buy a $100,000 computer server and have it installed before we can start. And so by getting a required operating environment, you can avoid that issue. All right. When I see failed IT projects, both in the health space, but also in other IT spaces generally, I'll say one of the common themes is almost always a massive turnover among vendor personnel. I had a case last year of a failed large system, IT system, and that project had 4 project managers in 1 year, and I kind of think, of course it failed. So make as one of your contract terms that the personnel assigned to your project will stay on your project through completion, unless they leave. Obviously, if someone has to leave because they leave the company, or if they're on a protected leave like FMLA, then you can't stop that. But you do want a commitment from the vendor to keep your team on your team. Also, just as a warning, a heads up, a lot of times costs like expenses and travel will be on a as incurred basis. Just warning that can be, depending upon where your vendor is and where you are, 15, 20% is pretty typical. I've seen some of this go as high as 25%, so that can be a major expense depending upon what you're looking at. All right, term and termination. I'm actually just going to go past this right now. Other than I will say this: if you are signing a contract for a multi-year term, 3 years, 5 years, 7 years, and I understand why people do that. Oftentimes, you're offered perhaps better pricing. The thing that you really don't want is to be stuck using a system that you are really unhappy with for a whole bunch of years or paying for a whole bunch of years. And I'll also tell you that as a person who deals with disputes, a quote termination for cause, that's hard to prove. Okay, that's very hard to prove. So if you can get some kind of a termination for convenience or early out or termination on 90 days or even 180 days, that's going to be a really valuable term for you. No plan to sunset. This is a warranty. Typically, you wouldn't want to buy a software system that you knew the vendor was going to let go of in 6 or 12 months. So I'll get a warranty that will say that there's a guaranteed support for 5 to 7 years. And if they don't follow through with that, you'll either get some money back or you'll get a free transition to the successor product. Especially for folks who are doing installed software, this won't surprise you. Almost any vendor you use is going to try to pressure you to switch to a cloud-based system because that's what venture capitalists and other acquirers and some money people want to see. And so if you do that, you'd like to get perhaps a free copy of whatever they're pushing you into. Warranties, we've talked about per documentation and incorporate that, comply with laws and regulations. Briar talked about that some. Non-infringement, that's an IP term. Nothing really to add there. Limitation of liability. So vendors are going to try to really limit their liability to fees paid. And sometimes it'll say even fees paid for the particular element. Like if one element doesn't work, they'll refund your money for that one element. And I feel like, you know what, if I knew that one element was going to work, I might have not purchased the whole thing. So I would say feel empowered to push back on that. with a particular carve-out where there should not be a cap on liability is the vendor's breach of business associate agreement, HIPAA violations, or confidentiality or security breaches.
Oh, one note on that. I am so sorry that that the slide on there has HIPAA with 2 P's instead of 2 A's. A personal pet peeve that I forgot to change in the slide. My apologies.
Sorry, that was my error. Indemnification, I'm not going to spend a whole lot of time on that. Insurance, particularly when working with a smaller vendor, you should require them to have some insurance to make sure that they can make good. The other thing I'll just say for you yourself is a couple of years ago, I would not have necessarily encouraged people to get cyber privacy or data breach insurance. And now that the price of that product has come down, especially if you go to the same insurance provider as is your general liability policy provider, that can be a more affordable product. So I'd say consider that. All right. Under privacy and security, we've talked about that quite a bit. Let me just here mention backup and disaster recovery. Quite a few EHR contracts will say that you are responsible for data backup or having an extra copy. If you're okay with that, that's fine, but just make sure that you know what's going on here. Particularly in a cloud environment, right? You would expect a vendor, if they've got the only copy of your data, to have a secondary copy in a geographically distant location. You know, people say 150 miles is kind of a norm, or further, that's on a different power grid. And some people are even saying, actually, after the giant storm of last year, that 500 miles is a better number, where you could get your alternative system back up in less than 24 hours. Support and maintenance. I'll move past that slide. And I think, are we now? Briar, is this yours or is this one of my slides?
Yeah, I just wanted to make a note, and you touched on this when you were talking about kind of IT obligations, but occasionally there will be a case where a vendor will be helping you to develop a database that is supposed to be used within your system so that you can run multiple other analyses to figure out any number of issues within your organization. And in some cases that can be developed and built up over time, and you add your own specific functions to that, and it becomes a really important part of how you are doing your own data analysis. If the agreement with the vendor terminates, what's going to happen with that database? We have seen cases where the vendor says, oh, that's too bad that you can't use that anymore because we've got real strong language in there about us owning it, and you can't let another vendor even look at that, much less alter it, so too bad for you. And that, again, you're in a much better position if you can negotiate terms around that before you get to the point of having to fight about it. Once it's 6 years down the road and that database is built and you depend on it, you have very little negotiating power at that point. So keep that in mind if you're going to be doing anything where you are adding to the product that the vendor has created. How's that defined? Who owns what and who can do what with it? Just a brief note on kind of data security issues related to the security risk analysis, but also kind of just general security. Who is helping you keep your data secure? Who's helping you keep your EHR secure? Many organizations now have a dedicated IT function within their organization, and that is great, especially for larger organizations. But for smaller groups, who is your IT person? Do they understand all of these many pieces that they need to be dealing with? Have you hired an outside security vendor either to help with the risk analysis or to do some testing for you? Are you relying on your vendors generally? So, are you relying on Epic to provide the security for your system? If you're only relying on your vendors who are also providing the products to you, that's a potential security concern. And then keep in mind your employees, not just your IT people, but your employees generally are your front line for a lot of data security issues. Note too, on when you are contracting, who is reviewing that vendor access to PHI and the EHR? We mentioned that a bit earlier. What kind of access do they need? But also, who is looking at that? Whose job is it? Who is making sure that there are firewalls in place so that a vendor doing maintenance doesn't get to peek into the clinical notes of whatever patient they want? Are the minimum necessary requirements for HIPAA being met by what you have in place? And then just a brief mention of some current events. And it looks like the GIF is working, so yay. Everybody that is on this call knows a lot about the various scary things that are going on in the healthcare world. There are problems out there. So one of them is phishing, and this has come up a lot recently. It's been happening for years, and it's getting more sophisticated. Generally speaking, it happens when some bad actor sends an email that looks real and is hoping to get users to click on that, to click on a bad link, and then the hacker does something nefarious with that access that they now have to your system. This case that is on the screen happened when 5 employees were compromised, and the phisher was able to access some records. It happened over the course of more than a week and wasn't discovered until a few months later. Patient information was in one of the breached employee email accounts. Patient names, medications, and treatments were there. So even though they didn't get access to the actual electronic health record, they did get access to some patient information. We've also seen some cases where employees fell for a phishing scam, and the phisher was able to make changes to the employees' direct deposit information and sending their direct deposits to a different account. So they can do bad things in a number of ways.
I'm just going to piggyback on that and say that the level of sophistication really has impressed in a bad way. Kind of amazed me, right? If only they could use their cleverness for good instead of for evil. But the thing that happened to one of my clients last month is the client was having an email exchange back and forth between the client and a vendor, and they knew each other, and so it was a very kind of back and forth normal email exchange. Every other day they'd email back to each other. Well, the bad guys somehow got into that exchange, and so then the bad guys began emailing to my client, posing as the vendor in the middle of the conversation, and said, "Oh yeah, and besides all the other stuff we were talking about, hey, we've got a new bank routing number. Here it is." And because it was so seamlessly moved into this existing email chain, the client did make the future payments to this other bank routing number, and only discovered later that they had sent, I'll say, a considerable sum of money to the wrong place, and we had to go try to chase it down and get it back.
Another bad, scary thing, ransomware. This is generally when there is encryption of files and somebody requests a ransom to get those files unlocked again. Sometimes those files are really necessary to provide care to patients, so it can be a huge disruption. The WannaCry ransomware incident was one that I think most of us had heard of. There was another ransomware scheme called NotPetya, and I think that both of those were the result of not patching when there was a patch available for a discovered security hole. And for all of these major ones that we hear about, there are lots and lots that we don't hear about. And instead of ransom in the $3.6 million of Bitcoin, it's $300 of Bitcoin. And as Steve and I were discussing, the FBI has given some informal guidance on that regard that is mostly, just pay that. Just pay the $300 to get your stuff back, because you're going to spend a lot more, and nobody has the ability to get it otherwise. So a very unsatisfying conclusion, but that is the unfortunate current situation.
I'll piggyback on that and say as well that that's part of why I mentioned earlier the whole issue of backup, because the whole solution to a ransomware, well, one of the solutions to a ransomware problem is that you say, fine, don't unlock my system, and I will just reboot or restore from a separate backup copy of the system. Actually, our firm has a couple of videos or some small function that is outside and not protected by a firewall. And I've heard from our folks at IT, once every 2 or 3 months, we'll get a ransomware demand saying, we've frozen your functionality. And we're like, yeah, okay, that's fine. You can freeze it. We'll just restore it from our backup. So hopefully you can have that ability as well if you've got a good backup system.
And our next problem is with information blocking. So this can happen when a vendor might deploy some products with limited interoperability on purpose, or tries to charge you an inordinate amount for exchanging information. Some of that was tried to be fixed with the 21st Century Cures Act that mandated for both vendors and providers that they make sure their information can be shared between providers for treatment purposes, demanded interoperability. HIPAA business associate agreement provisions also in general require compliance with HIPAA, which includes being able to provide patient access. So there are efforts to deal with the information blocking, but it can be more subtle than just somebody cutting you off from access, and so it can occasionally require some negotiation in that area. How to protect yourself from some of these scary things. Educating employees is very important. Although, you know, as Steve says, when you've got a very, very sophisticated hacker trying to get your information, it can be really hard to educate employees enough. Still, you can do testing, fake phishing emails, although, again, as Steve pointed out previously, you want to make sure that the people who need to know about that are aware of it and have signed on to that. But the fake phishing can kind of help you determine who might be clicking on things that they shouldn't and how to educate them a little bit. You should have a plan for if or when disaster strikes. Who's going to be in charge of your response, and what is the response going to be? You'll want to involve IT, your security officer, your privacy officer, figure out if legal authorities need to get involved, and maybe have lined up a potential cybersecurity partner to help you review the situation and determine what information was compromised. It feels not great when it happens and when the people who are in charge are saying, oh, well, who can help us figure that out? Is that a reputable company? And then you've got, with them, you need to review their vendor agreement and sign a business associate agreement with that entity. So it's not an immediate process, and when you would like it to be immediate, that can be problematic. There are some anti-malware tools that allegedly can predict malware. I don't have a lot of experience with those. I cannot vouch for how well they work, but have seen this as a recommendation.
I have not seen that before, and I have no comment on those tools.
Excellent.
If any of you have any experience with those, actually, feel free to ping us. We'd be interested to know if there's anything that you think is great or terrible.
Agreed. Patching on time, make sure your IT folks are doing their patches, because if there's something out there that you haven't fixed, you are not in a good position both for a hack and for somebody saying you should have fixed this and now you're on the hook for all these bad things that have happened. Other recommendations that I have seen that maybe don't always work out super well: no personal webmail on corporate connected devices. That can be really difficult depending on the size of your organization and people's dedication to having that available to them. Stephen mentioned data backups for a long period of time. Those are actually very useful, where if you're backed up for 2 months, you don't really care if somebody says, oh, we've taken all your stuff from the last week. As mentioned, maybe end up paying in ransomware situations. And as always, look at the options that make sense for your organization. So you can never guarantee complete protection, but you can make sure you're taking steps that are as reasonable as possible. Steve, any other recommendations for protecting yourself from disaster?
No, I thought that was a great, and honestly, you commented on training, and it's true. You know, I suppose there's some really sophisticated stuff out there, but you know what? I still get probably every 2 or 3 weeks an email telling me that there are millions of dollars coming from some foreign government if I only give them my bank account, and they'll transfer it in. I still have not tried that yet.
I've tried it a couple times. Neither time has it worked out well for me.
So I feel like there's I think that the whole education part that you mentioned is really valid.
And then I have got another question here that I didn't get to previously. The question is, what would you include in an agreement to protect yourself from the current ECW problems? And I'm going to assume ECW is eClinical Works and not the Central Wrestling Organization. But so eClinical Works, as many of you know, they paid $155 million to resolve a False Claims Act allegation related to customer kickbacks for publicly promoting products, but more significantly for our purposes, for having falsely obtained their certification when they concealed from their certifying entity that their software didn't actually comply with the requirements for certification. So how can you protect yourself from that? That is really difficult. You don't expect vendors to be purposely flouting the requirements of the government like that. So in the agreement, as we mentioned, having something in there about being a certified EHR is a good idea. And then you could also consider language that says not just that they are certified, but that they meet all requirements for certification. I think in both cases, if you have somebody who is purposely not doing what they're supposed to do, that's not going to help you a ton, but it does give you some leeway to come back later on and say you violated a material term of this by both not being certified and or claiming you were certified when you were not.
So, sometimes the law can help folks, and this is the case where I think that one of the things that you can't do at law is you cannot disclaim your own fraud or misrepresentation. And even if you say it, even if the vendor has a clause in the contract that says, we never give money back, we're not liable for anything. In the cases of really egregious conduct, those just won't hold.
I agree. And I think with that and our, you can see we both look the exact same way in these pictures, even though they were taken probably 10 to 15 years ago. I guarantee it. With that, I think we are wrapping up. If you have any further questions, feel free to contact either one of us at using those phone numbers or email addresses. And again, thanks so much for joining us, and please do fill out your survey.